Donald Trump now moves to dismiss certain charges in the classified documents case. This case, of course, taking place out of Florida, Judge Eileen Cannon presiding. And Trump submitted a whole slew of these motions, some dismissing the entire indictment, some only dismissing certain charges. And this one is based on presidential immunity. Reason why this is so important is because Trump is already battling another presidential immunity issue in Judge Chutkan's courtroom in Washington, D.C. So we're down in Florida here for classified docs on immunity, but we're also in January 6th case in D.C. on immunity, and that case is already at the Supreme Court. So now we have this possibility, we've been waiting for this, that there would be a conflict, okay? Because Cannon hasn't ruled on this yet. She's in Florida. Chutkan has. Chutkan came back out and said, no immunity, you're just a peasant defendant, you don't even deserve a due process at all, you don't even need to read the discovery. That's how monstrous you are, Trump. And so there is no immunity from her, but Cannon is not as psycho, okay? Not as anti-Trump as many others. And so this will be interesting to see if we have a circuit split and what the Supreme Court wants to do about this, or whether the Supreme Court clarifies this before this ultimately percolates itself up to their level. So we've been waiting for this, but before we jump into it, let me show you what else is coming. This came as a part of a giant package, and this is Trump's notice of their filing. And let me show you exactly what is coming. Trump submits this, a notice of Trump's pretrial motions and other hearing requests. He said, we got a mother load coming your way, and I'm just giving you notice of it. Says, all right, here, Judge Cannon out of Florida. Trump respectfully submits this response to your prior order. You told us that you wanted public notice of pretrial motions that we're going to be submitting, and we're doing that. And we also are setting forth Trump's position on why we need hearing on the motion. So they tell us, Your Honor, you gave us a deadline here, February 22nd. That's yesterday when this was filed. And so President Trump is filing the following pretrial motions as you indicated for us. We got a motion to dismiss, boom, counts 1 through 32 based on presidential immunity. That's what we're looking at here today. There's another motion that was submitted to dismiss the superseding indictment. Okay, so we're not seeing this one. It's based on selective and vindictive prosecution. So a motion to dismiss the whole thing because Jack Smith and the DOJ are targeting Trump specifically. Now, we're not going to see that one. That one was via email to the court. So the judge is going to review it. Remember, we're going to have redactions, and this is everything super sensitive because classified documents. We don't have that one in our possession. Also, a motion to dismiss, or in the alternative, to suppress the 15 boxes based on prosecutorial misconduct, resulting in due process violations, impermissible pre-indictment delay, and grand jury abuses. Another spicy one. Grand jury was abused by Jack. They waited, they delayed, waited for years to bring the charges in order to get an advantage, charging him in the middle of an election, saying other misconduct by Jay Bratt, who's down there in Florida, due process violations. That's a juicy one. Okay, that's like, yeah, we want that one. Now that was sent via email. We don't have it. We also have a motion to dismiss based on vagueness and unconstitutional, we don't know what the law says, and that's on the basis, so they want that one only for count 19, and so we'll save that one for next week. They say Trump possessed a valid security clearance at the time of this indictment, so counts 1 through 32 and 19 on vagueness. We'll save that one. We also, this one we'll get to in another segment, is a motion to dismiss the superseding indictment because Jack Smith has been illegitimately appointed. We're getting into that one soon. And a motion to dismiss based on the Presidential Records Act, right? These documents were Trump's. He didn't have any reason to give them back to you because they're his presidential records and his personal records. Now, a motion to suppress, so not dismiss any of the charges, but just to really silence the evidence, stop the evidence from coming in, suppress it. Evidence that was seized during the raid, and also stuff that was seized in violation of Trump's attorney-client privilege, and also dismissing the indictment based on prejudice from this privilege violation. Wow. Okay. So they're saying somebody who seized a bunch of stuff from Trump's house at Mar-a-Lago, somebody breached attorney-client privilege to such a monstrous degree that it needs to be dismissed. In other words, the sanction, the penalty for that is a dismissal of the case. That's how bad it is. And that is sent also via email. So good stuff. Now, they say, as discussed in each motion, Trump seeks discovery and pretrial hearings on factual disputes that are discussed. And we're prioritizing the hearings in the order listed. We want to go down this road. Now, however, Trump's top priority for pretrial motion practice is resolution of the pending motions about the order for the scope of the discovery. And remember, there are so many filings that are happening here. They're referencing a previous one that we covered here on our channel, which is about Jack Smith says that the scope of his prosecution is very small and narrow. He says it's like Jack and like a couple of bros. Molly, Jay, that's it. Secret Service, they're not part of our team. NARA, they're not a part of our team. CIA, no, definitely not a part of our team. Homeland Security, no. White House counsel, no. Trump people say, yeah, I'm sorry. They all work. Okay, Congress was, J6 committee was. They're all helping you bundle this up. You were communicating with NARA, you were communicating with CIA, what's classified, you were all in on it. So we need discovery from all of those people. Trump is saying that is our #1 priority. Now, addressing the dispute regarding regarding the scope of the team is necessary for several reasons, including the court's ruling. It's going to set the parameters for the rest of it. Like, a lot is contingent upon that. If you say, hey, you have access to the Secret Service, well, we're going to want all their records. Moreover, as noted previously, we also need this because there's a bunch of unproduced materials. Now, moreover, as noted, the court's rulings on the motions to compel, so whatever the judge rules, will likely require supplementation of other motions, right? So once we know that the Secret Service was in on it, the National Archives was in on it, CIA was in on it, we're going to have other things to talk about as soon as we know that. That's why we have to start there. Now, to the extent that Jack Smith disputes Trump's immunity, they say that Trump's decision to classify records as personal under the Presidential Records Act, they say that was an official act. They dispute that. So they say Jack Smith disputes that Trump and his ability, his decision to say those records are personal, meaning they don't go back to you, government, while he was still in office, was an official act. They say that's not official. They say fact-finding in the form of document disclosures and witness testimony is going to be necessary. So Trump says, I have immunity because my official act was designating these official documents as my personal records. So they were protected. Now they're not protected. Trump made that decision and they're not criminal anymore because they're now personal. He's the president. He has the power to do that. And again, he doesn't have to go through the National Archives and get permission from Deborah. So he makes this decision and they say they're contesting it, so we're going to have a hearing. We also are going to talk about selective and vindictive prosecution. This was filed under seal, emailed to the court for now. Now they say our motions to compel have already established a basis for discovery and a hearing on selective and vindictive prosecution because all we have to show is some evidence, a very low standard. Now the scope of disclosures and the hearing that are necessary is governed by another case. The office must produce from its own files documents that might corroborate our claims. And this is interpreted to the entire prosecution team. So we need all of that stuff and we need it now. They're also saying that there is prosecutorial misconduct. So in connection with Trump's motion related to prosecutorial misconduct, we need hearings on this. Or, this is our notice, we need hearings. We need to know the extent of the coordination and the underlying motivations, between everyone else who's involved in here, including Biden and his whole administration, NARA, the DOJ, the FBI, and Jack Smith's so-called office. We need to know, what were they saying? What were they communicating about? They were all colluding to go indict Trump, sending FBI agents there to scope the cameras. And we need to know about that. So let's have a hearing. Whether the government acted with the intent to gain a tactical advantage when they delayed this indictment. Obviously they did. They indicted a bunch of other J6ers, but not Trump. Why? Well, because it didn't matter. They weren't running for president. They weren't running for election. So who cares? Grand jury abuses concerning the timing and the conclusion by Jack's office that venue did not lie in DC, and the pretextual grand jury subpoena the office issued to NARA, and the purpose of those discussions with the special counsel's office, NARA, and the FBI. They were all involved. As to count 19, they say Trump is going to try to move this one because he actually did have Q clearance. Now, they tried to retroactively terminate that Q clearance, but he still had it at the time. Now, there was also a motion to suppress. They say, Your Honor, we need hearings on this one. There was an unconstitutional raid at Mar-a-Lago, and they violated Trump's discovery and his privilege. And so we need hearings on these things. We need a hearing concerning the execution of the raid and also about false and misleading omissions that led to the warrant in the first place. Whoa. So the FBI so-called agents, they fill this out. Government prosecutors, DOJ, they all do their due diligence. Well, he saw cameras and there were boxes and whatever. Trump thought he was like communicating with them. He's like, come on in. Hello, FBI. How are you? He walks in. Let us know if you need anything. And they say, no, we got everything. Here, we're scoping this out because we're going to indict you any day now. He's like, wait a minute. I thought we were negotiating. They're like, no, you're going to jail. So they're there. And then they applied for a warrant to go conduct the raid. And they say there was full of garbage in there. Misleading omissions in order to go get the warrant in the first place. Lied to the judge. Then there should be a hearing about the execution of the raid and the lack of good faith by the participants in the search. We need to see that. We also need a hearing concerning the ways in which Jack's office used privileged evidence during the investigation and the resulting prejudice, which is relevant to the motion to dismiss. Things are so bad that the case needs to be dismissed because they dumped all over his privilege, and saying there have been multi-day hearings on these privilege violations and resulting prejudice. And so that's the notice. Obviously, there's a lot that is coming, and we've been waiting for this day. It's like Christmas morning. Todd Blanche is here, Christopher Keese filing all of these documents, and this one is the notice. So there's a lot coming. Now, let's get into the big one. Trump files a motion to dismiss the classified documents case. This is based on presidential immunity, and it's only for counts 1 through 32. It's not the full indictment, but these are the documents violations themselves. And so let's take a look why this is appropriate. Trump's team tells us, all right, Judge Cannon, we're here, and we say Trump has immunity. They say Trump is submitting this motion seeking dismissal on the basis of presidential immunity. Why? All of these charges, counts 1 through 32, they stem directly from official acts while Trump was in office. You're saying, wait, how are they official acts? Because he moved the boxes. Maybe the boxes were moved after he was president. Maybe they were sitting there. So how does it work? Well, specifically, Trump is immune from prosecution for counts 1 through 32 because the charges turn on his alleged decision to designate records as personal under the Presidential Records Act. He decided those are not presidential records, which means they have to go into the government archives. Those are personal records. And there's a lot of history here, by the way. Clinton, for example, there was a sock drawer case that he had stuff in his sock drawer, apparently, and he said those are personal records. They're not presidential. And it went up to the Court of Appeal, or the D.C. Circuit, I think in the D.C. Circuit, or maybe just in D.C., maybe not the Court of Appeals, but they were there, and the judge said, who am I to overrule the president? Okay, it's the president. If Clinton says they're personal records, they're personal. And there's a separation of powers argument here also. How is she going to substitute her judgment for his? It's insane, because he's the president, she's a judge. So he decided that. So Trump made the same decision. They said, oh, can't do that, that's illegal. And then when he decided that they were personal, he then caused them to be moved, and that's illegal too. Those were the charges. Caused the records to be moved from the White House to Mar-a-Lago. Now, as alleged in Jack's indictment, Trump made the decision while he was still in office. Now, the alleged decision was an official act, and as such, is subject to presidential immunity. Now, the court should hold a hearing to resolve any of these factual disputes related to the official nature of Trump's designation and the removal of his personal records from the White House. Now, if after the hearing we do our job, the court should then dismiss those counts. Now, in the indictment itself, let me just detail what it looks like, because this was the original filing in Florida, the superseding indictment rather. And when you scroll down, you'll see this is the document section. So here, each document is a different count. So count 1, top secret, special handling. It's a various document concerning a White House intelligence briefing, right, from 2018. So these are old intelligence briefings that are just, mostly meaningless. So 2018, another document, okay, all the way up to count 33. So that's what we're talking about here. And a lot of these, they told us were like nuclear codes and stuff, and it's not, none of it is. I mean, at least in evidence, we haven't seen any evidence of that. So that's what they're talking about. They tell us. Now, the superseding indictment, in it, Jack himself concedes that the genesis, he wrote in there, the genesis of this case, it dates back to at least the tail end of the Trump administration itself. So he was the president. And they allege in it that Trump caused, that's the legal term, the subject caused the thing. We have causation, many of which contain classified documents to be transported. And so the indictment makes clear that this decision and the transportation occurred while Trump was still in office. They said Trump was preparing to leave. Okay, he was preparing to leave. That means he's the president. And Trump departed the White House prior to 12 p.m. on January 20th. And as such, he is alleged to have made these decisions about those documents while he was still the commander-in-chief. And as we've talked a lot about here in the Chutkan presidential immunity decision that's working its way on the J6 case up through SCOTUS, presidential immunity, according to Trump's defense, applies to all the actions in the outer scope, the outer perimeter of a president's duties. And making these decisions as you're wrapping up your affairs in the White House would clearly fall within that. So they say, well, let me tell you, Your Honor, about what you need to know in a motion to dismiss. They say an indictment may be dismissed when there is an infirmity of law in the prosecution, where immunity applies. You can dismiss. And an indictment that requires speculation is insufficient. It's got to have some more substantive and concrete data. So they tell us Trump is immune from prosecution. Now, a lot of this is going to mirror, I think, other arguments we've seen. But a former president's immunity from criminal prosecution based on official acts is a serious and unsettled question of law. And we know that those 3 ladies in Washington, D.C. at the Circuit Court of Appeals who didn't even sign their names to the opinion, the circuit recently erred. They say, we're going to the Supreme Court right now. The lower courts, they made a mistake. They found that Trump was not entitled to presidential immunity on the J6 case. But their analysis is terrible. It's not persuasive, as we'll talk about. Trump is pursuing that decision currently at the Supreme Court, telling this to Judge Cannon in Florida, including an en banc review back at the Court of Appeals in D.C., and will go to the Supreme Court if necessary. And so this court, Cannon, you should not follow, right? This is where we get the split. Do not follow Chutkan. She did bad, and the Court of Appeals in D.C. is bad. Here's why. Now, under the separation of powers, Article 3 courts lack authority to sit in judgment over a president's official acts. Otherwise, they're the president. If Deborah Steidel-Wald from the National Archives can tell Trump, you don't get to declare that a personal record, dictator, well, then she's the president, okay? Because that's his authority under the rules, under the Constitution. And we can trace this all the way back to the opinion clause, which is right there in the Constitution that says the president has the right to the opinions of his executives in writing. So it's all emanates from that, right? Even if you want to defer to the statute, let's see, they tell us. Now, a former president has absolute immunity for civil liability. That's the Fitzgerald case. And everything anything in the outer perimeter includes presidential decisions, that can reasonably be understood as the official actions of the office holder when they're exercising their official responsibilities. Winding up your affairs when you're finishing your term, part of your duties. Now, under the executive vesting clause of Article 2, the principles of separation of powers and so on, Article 3 courts cannot judge a president's official acts. The vesting clause says the executive power shall be vested in a president of the United States, not in Deborah, not in Chutkin. For another branch to arrogate the executive power to itself, to take it, or to purport to dictate how the president uses that is a violation of separation of powers. Otherwise, they're the president. Now, as a direct corollary, the clause also provides that the judicial branch cannot sit in judgment directly over a president's official acts, and that any attempt to do so violates those separation of powers. And we talked all about this a long time ago, Cannon. You know this, because you're smart. In Marbury versus Madison, Chief Justice Marshall described this doctrine as foundational, and it's self-evident, unless you're Judge Chutkin. By the Constitution of the United States, they said, in Marbury, 1803, long time ago, the president is invested with certain important political powers, and in the exercise of which he is to use his own discretion, and he's accountable only to his country and his political character and to his own conscience. He's the president. Now, when it comes to the president's official acts, whatever opinion may be entertained of the manner in which the discretion may be used, you might not like how it's used. Still, there exists and can exist no power to control that discretion. That's the court writing this. And Marbury is such a revered case because of this, because the court had the opportunity to gobble up a bunch of power for itself, to say, we actually can sit in judgment over these people, and they didn't. It's like, whoa, that doesn't happen. It's just like Washington leaving after two terms. It's like, whoa, the court could have, but they weren't power-hungry maniacs back then. They said, we have this separation of powers. They etched it in, and Marbury versus Madison has been one of the most seminal cases ever since because of that. Now, nothing can be more perfectly clear that the president's discretionary acts are only politically examinable. Otherwise, the court or someone else is the president. And questions which are, by the Constitution and laws, submitted to the executive, if it's their jurisdiction, they can never be made in this court. And so therefore, the president's official acts can never be examinable by the courts. And so, Cannon, consistent with this opinion, there's been an unbroken tradition from Marbury, that amazing case, to the present. It says clearly, Article 3 courts lack the authority to sit in judgment directly over a president's official acts. In 1833, citing the Marbury case, another brilliant judge called Justice Story, he said, in the exercise of his political powers, the president is to use his own discretion and is accountable only to his country, that's us, and to his own conscience. His decision in relation to those powers is subject to no control, and his discretion, when exercised, is conclusive. So Liz Cheney doesn't get to sit in Congress and say, Donald Trump should have texted a message earlier. None of that is allowed, okay? Nice opinion. Make your argument in the public opinion, make your political claims, and let the people decide. In Mississippi versus Johnson, another case, this court, which is Cannon's court, you cited Marbury, and you held that Article 3 courts lack jurisdiction to enter an injunction directly against the president in the exercise of his official duties. You guys wrote in this court, Judge Cannon, back in 1866, or maybe they're still talking about SCOTUS. I think they're citing this. Anyway, someone cited this. This is a Supreme Court case from 1866. So whether SCOTUS said it and Cannon is citing it, it came from SCOTUS. An attempt on the part of the judicial department of the government to enforce the performance of such duties by the president might be justly characterized in the language of Chief Justice Marshall. In other words, if you try to get the president to do something, if the courts use an injunction, which is an order from the court to do something, either to stop doing something or to go do something, if you try to enforce the duties of the president, that might consider, make them do something, that would be an absurd and an excessive extravagance. You can't do that. Now, we've also talked about the distinctions, okay? Like an injunction against an executive person is different than the president, right? Because now that there is balance of power there are checks and balances. They say this court has no jurisdiction of a bill to enjoin the president, that position, in the performance of his official duties. Also, in 1948, this court also wrote that whatever the order emanates from the president, whatever of this order emanates from the president, is not susceptible to review by the judicial department. The judicial branch cannot require the president to exercise his executive power in some judicially prescribed fashion. That's crazy. It's incompatible with his constitutional position that the president is being compelled to personally defend his executive actions before a court. Why? He has the power to do it. He doesn't have to come answer to you. You don't have power over the presidency. And so thus, all that being said, Article 3 courts lack jurisdiction to enter an injunction against the president in the exercise of his official responsibilities, and no court has even entered a declaratory judgment against the president in his official acts. Now, the D.C. Circuit observed in Franklin that in general, this court has has no jurisdiction to enjoin the president. With regard to the president, they also said this: courts do not have jurisdiction to enjoin him and have never submitted the president to declaratory relief. Now, this is also the consistent litigation position of the DOJ that usually oversees the special counsel. But since Mississippi, courts have continued this practice and have sustained this without exception. Now, obviously, subordinate executives, as we said, they can be the subject of other court action, and such review may reflect indirectly on the lawfulness of the president's directives, but the authority of the judicial review of the official acts of subordinate officers has never been held to extend to the president himself. There has been an unbroken historical tradition implicit in the separation of powers that says the president can do what the president does. Now, these two lines of precedent, that the court may not sit in judgment over official acts, but they may review the validity of subordinate acts, has coexisted in harmony for centuries. And so, canon, the executive vesting clause and the separation of powers, they prevent courts from judging a president's acts, official acts. Under this principle, no Article 3 court has jurisdiction to enter an injunction, and no court has even made a declaratory statement. Now, the authority asserted by Jack here, that he just came up out of nowhere to put a president on trial, enter a judgment against him, and punish him with imprisonment and criminal penalties for his official acts, is a core violation of the separation of powers that our country knows and loves. And so, they say the impeachment judgment clause also confirms presidential immunity. And the impeachment judgment clause, they'll explain to us here, they say that this is something we can draw from that. The impeachment judgment clause says that judgment in cases of impeachment shall not extend further than to removal of office. Now, this was the understanding of the founders. James Wilson, who had participated back in the Philadelphia Convention when the document was first drafted, he said, the president is amenable to the laws in his private character as a citizen and in his public character by impeachment. Official and unofficial distinctions there. Now, with respect to acts taken in the public character, that is official acts, the president may be disciplined principally by impeachment, but not by private lawsuits for damages. But he's otherwise subject to the laws for purely private acts. Hamilton, James Madison, Federalist number 43. If you don't like what the president did, then you can undermine their immunity. It's very simple. All you have to do is impeach them and convict them. And every founder that we've seen here is very much in sync with that because it's logical. It makes sense. Justice Alito also recently noted this. They said the plain implication of the impeachment clause is that in criminal prosecution, like removal of the presidency, it's a consequence that can come only after the Senate's judgment, not before. This was how Hamilton explained it as well. He said a president may be impeached, tried, and upon conviction would be afterwards, after the conviction, would then be liable to prosecution. And that is obvious, right? They also say the president is in a unique position. This is a point we make here regularly, that the president is the root source of the executive branch. It is ground zero. It all emanates from them. And so if you start to say that the president is subordinate to other things, it wrecks the whole order. They say Fitzgerald also recognized presidential immunity is rooted in common law and under the separation of powers under the Constitution. And that's how it works. If it's going to be separate, it's got to start somewhere. The president occupies a unique position in its constitutional scheme. They say under Article 2, Section 1, the president is the chief constitutional officer of the executive branch, entrusted with supervisory and policy responsibilities of utmost discretion and sensitivity. Nor can the sheer prominence of the office be ignored. In the view of the visibility of his office and the effect of his actions on countless people, the president would be an easily identifiable target for criminal prosecution in countless federal, state, and local jurisdictions across the country. And that all emanates from Fitzgerald. Now, cognizance of this personal vulnerability of the presidency could distract the president from his duties to the detriment of the entire country. And the unique status of the president under the Constitution distinguishes him from other executive officials. As a result, the singular importance of the presidential duties, diversion from those duties, would be a big problem, saying without immunity from criminal prosecution, the political opponents will seek to influence and control his or her decisions via de facto extortion and blackmail with the threat, whether it's explicit or not, of future prosecutions. And this threat will hang like a millstone around every future president's neck, distorting presidential decision-making and undermining their independence and clouding their ability to deal with their tasks. Also, history supports this. The presuppositions are supported in the traditions of history. It dates back to Marbury versus Madison, as we already discussed. And also Charles Lee, he was the Attorney General under President Washington and Adams. Charles, he said, he declared it to be his opinion, grounded in a review of the subject, that the president is not amenable to any court of judicature for the exercise of his high functions. The Attorney General under Washington and Adams. You're not responsible to the courts as long as you're doing your official duties. That's your discretion. If you don't like it, you can be impeached. Now, indeed, in 234 years, from 1789 to 2023, no president was ever prosecuted for his official acts till today. Now, perhaps most telling is the lack of precedent. There was an unbroken tradition of not doing this. A lot of people had the opportunity to. We got American history abounding with examples of presidents who were accused by the opposite side of committing crimes. Happens all the time. But nobody ever actually prosecuted someone until it's Trump. Many other allegations. John Quincy Adams had the corrupt bargain with appointing Henry Clay as the Secretary of State. George Bush, false claim that Saddam had weapons of mass destruction. Remember that one? Led to war. Thousands of Americans were killed. Obama, he apparently authorized a drone strike that killed a U.S. citizen abroad and his son, who was also a U.S. citizen. Many others. Clinton, his last-minute pardon of fugitive financier Mark Rich. Clinton's repeated use of airstrikes. November 1998, he attempted to distract the nation from the Monica Lewinsky scandal, starts bombing other countries. His egregious mismanagement of border security under Biden. Biden's material support for terrorism through both the funding of the UNRWA. Gives them a bunch of money, more terrorism goes on. Now, despite numerous examples of presidents committing supposedly criminal behavior, no one's been prosecuted. The presuppositions of our political history confirm prosecutors and courts lack the authority to prosecute presidents for their official acts. Now, analogous immunity doctrines also favor this, right? President should have immunity because a lot of other people do. Common law extends both to civil and criminal liability immunity, and members of Congress are immune from criminal prosecution as long as they're doing their legislative duties. They're immune. Speech and debate immunity, it resembles presidential immunity because it preserves the separation of powers in our constitutional structure. Presidential immunity serves just as important role in our government. And we also have judicial immunity. That protects state and federal judges from criminal prosecution. It's the same thing here. It should also apply the same reasoning for judges and congresspeople. It also applies to Trump and to all presidents. Now, you should consider public policy concerns as well. Be sure that you understand what's happening here. And public policy overwhelmingly favors immunity. First, robust immunity is appropriate for officials that have sensitive duties. And it's most appropriate for officials for whom bold, unhesitating action is required. That's the president. In other cases, the Supreme Court noted, this concern is essential. The threat of criminal prosecution poses a greater risk of deterring bold and unhesitating action if you're constantly under threat. The president's focus should not be blurred by worrying about subconsciously the prosecution. The threat of prosecution impedes their ability to deal fearlessly with the duties of the office. We also don't want the president to be harassed by vexatious actions, by Fannie, by Tishy, by Jack, and all of them. And so under these standards, they say counts 1 through 32 are literally Trump's official acts. Under these standards, Trump's decision to designate these records as personal and cause them to be removed, which is the entire basis of the first 32 counts, it was an official act by the incumbent president. And as has already been held, absolute presidential immunity from civil liability includes everything in the outer perimeter, and so that civil liability protection should also extend to criminal prosecutions. They say President Trump and his decision to designate these records as personal, not presidential, and cause them to be removed, it plainly constitutes an official act in the outer perimeter of his duties. And as discussed in more detail in a separate motion, the president maintains exclusive responsibility for these things. Now, the DOJ had previously taken that same position. They said that President Clinton presumably classified the tapes as personal records by not transferring them to the archives. This is the case I was talking about from the DC district, the DC circuit. Says Judicial Watch, they sued for Clinton's records, and Clinton said, no, you don't get them. They're personal. And how did he decide that? By not transferring them. It wasn't like he went to Deborah and Nara and filled out a form. He just moved them. Those go there, meaning those are mine. Okay, that's the president. He doesn't have to go there and fill out her stupid form. The box 30. No, I'm the president. I have the power to do it. Get out of here. Fill out the forms yourself. And they gave Clinton that benefit. Drives me nuts. This is exactly what Clinton did, and they didn't charge him or raid his sock drawer, and they would have needed a biohazard suit to do that one. But the special counsel's office should not be permitted to take a contrary position now. However, to the extent that their office disputes the official nature of the Presidential Records Act and his decision to remove these, we need to have a hearing on this. We already know there's an outer perimeter test that says what we can do and what not do, so we need to have a hearing on this. Here, the president exercised his inherent executive authority to organize and dispose his own records, and he acted in accordance with the law. And even if Jack could establish that Trump's designation under the Presidential Records Act was illegal or otherwise improper, and they can't, the president's actions do not fall beyond the outer perimeter of his official responsibility merely because they're unlawful or taken for a forbidden purpose. SCOTUS has already held that repeatedly. And after all, every claim of immunity is raised against allegations of improper motive, right? So Jack says immunity doesn't apply because he wanted to take them for a forbidden purpose, and therefore immunity is breached. And he says, no, you don't get to just claim that and say immunity is breached. That's why we have immunity. So he continues saying, therefore, Trump is entitled to immunity for his official acts because the improper manner or the purpose of the alleged acts is not relevant. And so Todd Blanche and Christopher Keese, they say the charges in counts 1 and through 32 cannot be adjudicated. You cannot make a decision on that without sitting in judgment over Trump's official acts. It's in the indictment. And Chief Marshal, Justice Marshall, in the Marbury case said those can never be examinable by the courts. And so accordingly, and for the foregoing reasons, the court should hold a hearing if necessary to resolve any factual disputes about these official acts and dismiss those counts 1 through 32. And it's another great motion. I really think they have the law right on this because it makes sense. It makes logical sense, even for Bill Clinton, okay, and other presidents. If they have to go get a permission slip from someone else in charge to do the things that they do, well, then they're not really their documents, are they? And it doesn't comport with the executive branch and their articulated powers under the Constitution. And they are trying to apply a different set of rules to Trump, and they're getting called out on it. Now, this is not Washington, okay? This is Florida. This is Cannon's court. So she's going to have a different take on this than Chutkan did, and then those 3 ladies in the DC Circuit did. And we're going to be here to see what her response is, and Jack Smith is going to reply as well. Now, Trump was out talking about some of his cases, including the J6 case and some of the J6ers who are constantly under attack here as a result of these prosecutions. And this came over from X. Trump was speaking, and he was explaining that when he wins this again, he's going to reverse these monstrous abuses of power, get our justice system back on track.
To reverse these monstrous abuses of power, the moment I win the election, I will appoint a special task force to rapidly review the cases of every political prisoner who has been unjustly victimized by the Biden regime.
Definitely going to have their work cut out for them, and that's going to be fun to watch as that committee forms and unfolds. And so that, my friends, is it for us on this segment, and we are going to continue to cover this. We're going to see what Jack Smith says in response to this when his motion drops. We'll be here covering it, but it is a good filing, and we're looking forward to seeing what Cannon says because I don't think it's going to be the same as Chutkan. And so thank you for subscribing as we cover this case and all of the other Trump prosecutions and ballot removals and civil fraud cases and the rest of them. And we're going to be here hoping to see you here on the next one.